Hi, this is Keena Kim with PivotalDiscovery.com, and today we're here at the Masters Conference with Michael Leonard, who's with Womble, Carlyle, and he's going to share with us a bit of his career path. Michael, thanks for joining us.
Great. Well, I started out in 1978 practicing law in the very litigious city of Birmingham, Alabama. And great plaintiff's bar there, great defense bar. To have a great defense bar, you got to have a great plaintiff's bar, and vice versa. And so started out there, tried cases in Alabama, took appeal to the Alabama Supreme Court and the 11th Circuit Court of Appeals. Went out and argued motions for summary judgment in places like Etowah County, Alabama, and Fayette County, Alabama, which, the kind of place where you drive up to the courthouse and the guys, at least in Fayette County, the guys in the bib overalls see you drive up, and because there's a little going on in town, they follow you into the courthouse to see what you're doing. You actually get up and follow you around and stand there to see what you're doing. So I've been there, and after that, I got involved in some very large business cases in Alabama, banking cases actually. And then about '86, I was lured back to my home state of North Carolina by Womble Carlyle to get involved in some mass tort litigation, got involved in huge discovery, and that evolved eventually, as it would, into eDiscovery in the late 90s, primarily the late 90s and the early part of this decade.
Now, you seem to have a lot of experience in eDiscovery. Do you have any tips for those attorneys and firms that are newer to eDiscovery?
I would say keep it in perspective. The sky is not falling. We very often in eDiscovery, and one thing that disturbs me about it the most is people don't approach it with basic concepts of relevance. You start with the basic concept of relevance in the Federal Rules of Civil Procedure. You don't have to wander off into all these irrelevant rabbit holes and nooks and crannies. If you keep it focused on what is really relevant in the case and argue for that. And stand and be willing to take a risk on it. I mean, litigation is all about risk. Be willing to stand for it. Then the sky won't fall. You can keep it under control.
Great. Well, thank you for sharing your thoughts with us today.